Government business. Notice number 2, Copyright Amendment Outline Infringement Bill 2018.
I present the Copyright Amendment Online Infringement Bill 2018 and the explanatory memorandum.
Clerk.
First reading a bill for an act to amend the Copyright Act 1968 and for related purposes.
Minister.
I move that this bill be now read a second time. Australia's copyright system provides the legal basis for supporting Australia's creative industries and ensuring that they are viable and successful. It is an essential mechanism for rewarding the creative efforts of authors, artists and musicians, and the investors who take the risks to bring creative works to the market. Our copyright system balances incentives to create and disseminate new works by allowing fair access and use of these works by Australian consumers and other users for public policy benefits. The Australian government has made 2 major updates to this system over the past 3 years. These updates have given the disability, education and cultural sectors enhanced use of copyright material. Those reforms were long overdue and necessary to enable those organisations to go about their normal functions without harming copyright owners. Now it is time to provide our creators and copyright industries with updated tools to ensure their creative efforts do not go unrewarded. Australian film, television and music is a major success story, and the digital age has created opportunities for consumers to access this content in new and different ways. Streaming of content through providers such as Netflix, Stan and Spotify has opened up new ways of enjoying content. The government encourages the ongoing development and rollout of these legitimate platforms because they enable Australian creators and investors to be appropriately rewarded for their efforts. But the internet continues to create major challenges for Australia's creative industries. Online copyright infringement reduces the livelihood of Australian creators and investors, and foreign-based websites continue to illegally distribute the content of Australian copyright owners. The operators of these sites are often difficult to find and are located in countries that do not have strong copyright laws. In 2015, the government introduced a website blocking scheme in the Copyright Act 1968 to provide a means of addressing large-scale copyright infringement by overseas operators. The scheme has been successful. Since it was introduced, a number of sites have been blocked and there has been a reduction in the rate of online copyright infringement by Australian users. Research commissioned by the film industry shows that traffic to blocked sites in the months after blocking dropped by around 50%. That is an encouraging result. But in an environment that is subject to continual change, we need to make sure our regulatory protections are up-to-date and effective. Australia's piracy rate still remains higher than in countries with strong copyright enforcement frameworks, such as the United Kingdom and Canada. There is still a proportion of Australian users who seek out infringing sites, and there are still pathways for them to get to these sites, including blocked sites. In February this year, the government reviewed the existing scheme to determine whether it was operating effectively. In general, this assessment found that the scheme is working well and that blocking arrangements have been implemented by carriage service providers with minimal disruption. However, there are some clear pressure points. First, search engines enable users to discover the existence of blocked websites and provide alternative pathways to get to those sites. Second, the types of online piracy have also become broader, with increased uses of sophisticated online locations, such as Cyberlockers, that allow mass file sharing. Third, new pathways to the blocked sites appear after the initial blocking. and these new pathways can't be blocked because they are not part of the original court order. Finally, it can be difficult and costly to determine whether an online location is in fact located overseas. The bill directly addresses these concerns. It will allow injunctions to be made against online search engines who would be required to take reasonable steps to remove search results that refer users to an infringing online location. This will remove links that allow users to discover the existence of websites that may be the subject of an injunction. Some of these appear on the first page of search results when they should not appear at all. Search engine results can also disclose alternate pathways to blocked websites, which can undermine the effectiveness of blocking orders. The bill will provide that an injunction may be granted in respect of an online location that has, quotes, the primary purpose or the primary effect, close quotes, of infringing or facilitating an infringement of copyright. This will ensure that some overseas online locations, such as certain cyberlockers, may be captured under the scheme. Some cyberlockers are widely used as sites for sharing infringing music and movie files. At the moment, there is doubt about whether these sites have the quotes primary purpose, close quotes, of infringing copyright or facilitating the infringement of copyright. The bill will enable sites such as these to be brought within the scheme. The bill will make clear that the federal court has the power to issue responsive and adaptive injunctions without the need for the copyright owner to go back to the court. This will give the court the power to grant injunctions on terms that allow the copyright owner and carriage service provider by agreement to apply the injunction to block other pathways that start to provide access to an infringing site. The bill will also introduce an evidentiary presumption that will provide that an online location is outside Australia unless the contrary is proven. None of these measures will impede or affect the capacity for carriage service providers or search engine providers to voluntarily block or remove links to copyright-infringing online locations. Indeed, if these voluntary arrangements are effective, injunctions are unlikely to be needed. However, these legislative changes provide an important fallback should industry initiatives prove to be inadequate or ineffective. Mr Speaker, the government is seeking quick passage of this bill so that Australia's creative industries can take action to protect their rights. These industries have put in place voluntary measures to make content more accessible and cheaper and run education campaigns so that Australians are aware of the impact of piracy. It is now appropriate for the Parliament to support these efforts by reforming our copyright website blocking scheme to ensure it is fit for purpose in a contemporary digital media environment. I commend the bill to the House.
The debate must now be adjourned. The member for McMahon.
I move the debate be adjourned.
I thank the member for McMahon. The question is that the resumption of the debate be made an order of the day for the next sitting. All those of that opinion say aye. Contrary, no. The ayes have it. The clerk.
Government business notice number 3, Agricultural and Veterinary Chemicals Legislation Amendment, Streamlining Regulation Bill 2018.
I call the minister.
Thank you, Mr Speaker. I present the Agricultural and Veterinary Chemicals Legislation Amendment, Streamlining Regulation Bill 2018 and the explanatory memorandum.
The clerk.
First reading, a bill for an act to amend the law relating to agricultural and veterinary chemicals and for related purposes.
The minister.
Mr Speaker, I move that this bill be now read a second time. Mr Speaker, it's a pleasure that I move the Agricultural and Veterinary Chemicals Legislation Amendment, Streamlining Regulation Bill 2018. Mr Speaker, Australians need access to safe and effective agricultural chemicals and veterinary medicines. They protect our crops, livestock and domestic pets, safeguard our environment from invasive weeds and pests, and meet consumer needs for things such as household insecticides. AgVet chemicals, as these products are commonly known, have brought long-term benefits to Australian agriculture by supporting increasing productivity, better quality produce and more competitive industries. Ag-Vet chemicals will play an important part in helping our agricultural sector achieve the $60 billion worth of farm production forecast in 2018-19. It's important that the regulation of Ag-Vet chemicals continue to be streamlined to maximise the benefits for all Australians. It is also imperative to ensure that the strong safeguards built into the regulation of Ag-Vet chemicals are not compromised. Through a cooperative scheme with the states and territories, the Australian Pesticides and Veterinary Medicines Authority, the APVMA, is the national regulator of Ag-Vet chemicals up to and including the point of supply. The APVMA has an important role in ensuring that Ag-Vet chemicals supplied in Australia are safe for people, animals, plants and the environment and don't adversely impact our trade market access. The APVMA also needs to be efficient and effective in its regulation of Ag-Vet chemicals. This bill furthers these objectives by streamlining regulatory processes while retaining protections for the health and safety of humans, animals and the environment. The bill makes changes to enable the use of new, simpler processes for chemical product assessment based on risk. These changes support improved access to safe and effective chemical products and reduce costs associated with their registration. They do this by better aligning regulatory effort with risk and reducing red tape. The bill specifically provides for new prescribed approval and registration processes that will be quicker and less costly than those currently available, while also ensuring these products remain safe and effective. These new processes will apply for those active constituents, chemical products and labels that require minimal or no assessment of technical information. This measure has the potential to free up the time of the APVMA's assessors so they can focus on more complex assessments. The bill also provides for incentives for registration holders to include certain uses of chemical products on labels that they will not ordinarily register. This will encourage more minor and priority uses to be added to labels, where the costs of adding those are not justified by the additional commercial returns to chemical manufacturers. For example, where a chemical product is needed to control pests in a high-value, low-volume export crop, or where a chemical product is needed for a niche crop or to deal with a particular regional pest. These uses will improve productivity for farmers by allowing access to a wider range of safe and effective agricultural chemicals. Similar to the approaches applied internationally, the incentives in the bill operate by extending data protection periods on information for up to 5 years if certain uses, such as minor and priority uses, are included on labels. These